The Supreme Court today has finally given judgment on the 2023 presidential election, declaring that President Bola Tinubu was duly elected President of the Federal Republic of Nigeria. The Supreme Court said that failure of the IREF to upload result cannot, stop collation, and as such cannot invalidate the outcome of the result. Welcome to my channel, Shini's Digest. I welcome on board my new subscribers as I continue to appreciate my returning subscribers. This is the channel where we get to speak out and say it as it is. And whether the failure to upload result on the IREF portal can invalidate the outcome of the election results, hear what Justice Okoro has to say on this as well. Take a listen.
The thrust of issue 1 is whether the lower court was right in refusing to hold that the failure of the first respondent to electronically transmit results from polling units nationwide for the collation of results introduced by the Electoral Act 2022 and specified in the regulations and guidelines for the conduct of elections 2022 and manual for election officials 2023 does not amount to non-compliance, which substantially affected the outcome of the election. The lower court held that the IREF is not a collation system, and I agree. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit result real-time to the IREF portal. According to the appellants, this was enough to nullify the election of the second respondent. What exactly is the IREF portal? This is what the court has to say. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IREF portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My lords, having failed to prove its petition by conventional method known to this court, the appellants urge this court to depart from several decisions of this court on ways of proving non-compliance. They have not shown that those judgments were reached per incuriam or that there was any miscarriage of justice. See some cases cited. On the whole, it is my well-considered opinion, which accords with the views of this court, but the court below, that the failure to transmit result to the IREF did not affect the result of the election. Accordingly, this issue is resolved against the appellants.
On the issue of the failure to achieve 25% vote cast in the FCT, the Supreme Court holds that again cannot invalidate the outcome of the results. Hear what Justice Okoro has to say on the issue of 25% vote cast in the FCT. Take a listen.
The second issue is whether the court below was right in its interpretation of the provisions of Section 134 sub 2b and Section 299 of the Constitution of the Federal Republic of Nigeria as amended, in holding that securing 1/4 of the total votes cast in the Federal Capital Territory, Abuja, is not a constitutional requirement for the valid return of a candidate as duly elected President of the Federal Republic of Nigeria. In his argument, the learned senior counsel for the appellants urged this court to interpret the word "and" in Section 134 2b of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory before he can be President of the Federal Republic of Nigeria. The lower court made the following decision, and I quote, "As expressly stated in Section 299 of the Constitution for the purposes of fulfilling the requirements of Section 134 sub 2b of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states of the Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to secure 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did." End of quote. To be very honest, I do not see anything wrong with the above decision. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court must give the Constitution or a statute a purposeful and people-oriented interpretation. What I'm trying to say is that in interpreting the Constitution or any statute for that matter, a narrow and selfish approach should be avoided. The duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is trite that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. Let me drive this matter home. The poster rendered by the learned senior counsel for the second respondent in their brief comes handy. Assuming that a candidate scores the highest number of votes in a presidential election and has 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT, are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of 1/4 of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and I resolve it against the appellants.
On the issue of bringing in fresh evidence after the statutory 21 days given to petitioners to file in their case, the Supreme Court holds that also cannot be extended or enlarged after the date of declaration of the election result. That the fact that Atiku was trying to bring in fresh evidence after 21 days only amount to him trying to sneak in evidence through the back door, and also an attempt by Atiku to rewrite the Constitution or the electoral law. Hear what Justice Ian has to say on this.
The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration of the time? The obvious answer is no. This court held that applications for extension of time to call additional witnesses and to file additional witnesses' statements after the prescribed period for presenting election petition are not permitted, because election matters are time-bound, and by reason of being sui generis, the procedure in handling them are stricter than ordinary civil matters. A combined reading of Section 285 sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 45 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses, the election petition, proceedings is 21 days from the date of declaration of results. In reply, the three senior counsel for the respondents in their various briefs submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise, and that paragraph 45B of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be trampled upon by allowing new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants. Taking the first condition, for example, the appellants failed to convince this court on why it waited until after the court below delivered judgment in the petition and lost the 180 days donated to it by the Constitution before bringing the said depositions sought to be admitted in this court. It has to be noted that appeals are a continuation of hearing of the matter in the lower court. As was pointed out by the learned senior counsel for the first respondent, A.B. Mahmoud Essay, the presidential election was conducted on the 25th of February 2023, and the first respondent declared the second respondent as winner of the election on 1st March 2023. Thereafter, the appellants filed their petition at the registry of the court below on 21st March 2023. If I may ask, what attempts did the appellants make between the publication of the second respondents from EC 9 and accompanying documents in June 2022, more than a year ago, and the date of filing the petition on 21st of March 2023 to obtain the document from Chicago State University, which could have been used at the trial court? Again, what attempts did the appellants make to obtain these documents between the date of filing the petition and the conclusion of trial? The application, my lords, of the appellant's applicants in the circumstance is thereby refused and accordingly dismissed.
So with this, the Supreme Court affirms the decision of the lower court, that's the Presidential Election Petition Tribunal Court, that Asiwaju Bola Tinubu was duly and lawfully elected the President of the Federal Republic of Nigeria. More details on this to come your way, guys.
Now that your mandate is short, sir, and Nigerians are now waiting to see what comes from this administration. So how are you rewarding Nigerians with the mandate given to you, Your Excellency?
I've started from day one to work hard, regardless of, the court cases, okay? And just strengthen my resolve to do more work, and more hard work, more dedication. Just appeal to the sense of patriotism of Nigeria to have a change of mindset. That we have a change of mindset for the sake of our country. Not for us, but for our children and grandchildren, great-grandchildren, the inheritors of tomorrow.
So this is where I draw the curtain for today. Thank you for always finding the time to watch my video. If you like the content of this video, please do give it a thumbs up. Strike on that notification bell so that you get to be notified whenever I upload a content like this. Leave your comments down below and do not forget to subscribe to this channel. Stay awesome. See you pretty soon. Peace as always. Out.